Supreme Court of Maryland, draw near and figure. The court is now in session. God save the state and the honorable court.
Good morning. Please be seated. Welcome to the Supreme Court of Maryland. It is Tuesday, April 8th, 2025. We only have one matter on the docket this morning. Danshin v. State, case number 39 of the 2024 term. Ms. Coleman.
Good morning, Chief Justice Fader, members of the court, Mr. Donahoe. May it please the court, Megan Coleman on behalf of the petitioner, Sergey Danshin. The issue before this court is whether the trial court failed to propound the defense of others jury instruction, both perfect and imperfect, when the defendant denied being the shooter, but there was evidence of his state of mind at the time of the shooting. The standard of review is whether some evidence has been produced, whether the evidence considered in a light most favorable to Mr. Danshin, together with the proper inferences to be drawn therefrom, is sufficient to establish a prima facie case of defense of others. Respondent, citing to Jarvis, acknowledged that whether the instruction is applicable is akin to assessing the sufficiency of the evidence. Therefore, it does not matter whether the evidence should have or probably would have persuaded the majority of fact finders, but only whether it possibly could have persuaded any rational fact finder. Keeping that standard in mind, I submit that the evidence in this case, with all reasonable inferences drawn in favor of Mr. Danshin, was sufficient to establish a prima facie case of defense of others that should have gone to the jury. That is, there is some evidence that possibly could have persuaded any rational fact finder that at the time of the shooting, Mr. Danshin actually believed that Christina Jones was in immediate or imminent danger of death or serious bodily harm, and that his purpose in shooting Mr. Gonzalez-Mena was to prevent that from happening. Now, I would like to begin with Mr. Danshin's statement to the police, which I submit is replete with shreds of evidence as to Mr. Danshin's state of mind at the time of the shooting. Arguments by respondent that words or phrases could be inferred differently are arguments that the state could have presented to the jury, but that's not the test for whether or not to propound the instruction. In Mr. Danshin's statement, he describes overt assaultive acts that he observed Mr. Gonzalez-Mena committing. He describes his knowledge of prior assaults and threats that Mr. Gonzalez-Mena made to Ms. Jones and that had occurred earlier that evening against Mr. Danshin. Mr. Danshin also explains his motivations and the why for the shooting. Mr. Danshin says, "I did what either of you would have done in that situation. There were two guys with machetes, and he did this to her and was like pulling her back into the room." And on State's Exhibit 96, which is the video interview, he shows that he's pulling his head backwards as if Ms. Jones's hair is being pulled back by Mr. Gonzalez-Mena.
If that was the extent of the evidence, just pulling back the hair and going into the room, would you think there was enough to generate the defense of others instruction?
If it was just what I said, without getting into the additional evidence as well as the inferences in his prior knowledge of the threats that Mr. Gonzalez-Mena made, I would say that that situation perhaps is a little bit more aligned with the Jarvis case, where the defendant in Jarvis said, "Well, I grabbed because I thought he was going to punch or he was swinging his arms, not I stabbed because I intended to kill him in order to prevent death." But unlike in Jarvis, there is much more evidence in Mr. Danshin's case. So the first thing that Mr. Danshin says, of course, the overt act, is seeing her being dragged by her hair back to the motel room. He says, I shot. The motivation behind this, I didn't shoot him." And again, we acknowledge that Mr. Danshin throughout this interview is trying to avoid saying those words because
Except he did, though.
He did. He did ultimately.
On page 355 of the extract, the question is, that's the last little piece of the puzzle we're trying to see to get to the why. Like, why did you shoot Javier?
I gave you the why.
I gave you the why.
Yes, Your Honor. And that's why reading the statement in order is important because clearly at the beginning of the interview, he is playing with his words. He is dancing around, and the detectives acknowledge that. They say to him, we appreciate that you're playing with words. We understand you're in a tough situation. Mr. Danshin says repeatedly, I don't want to confess to a crime. I don't want to die in jail. I want to hold on to the last shreds that I can to save myself. But he does ultimately come around, Your Honor.
Can I ask you this question? Respond to the majority's decision in the ACM decision that says it's certainly his right to choose his own trial strategy, but he can't have it both ways, claiming his innocence while also shooting Gonzalez, Menez, within Jones. They cite the Sims case, with the parenthetical, they say the issue in this instance involved the honesty held subjective belief of the perpetrator at the moment of the shooting. The defendant maintains that he is not the perpetrator. This becomes very difficult, though probably not an impossible burden to meet. Can you respond to that?
I can, Your Honor, and I'd like to talk about the Sims case and why that case is not this case. In Sims, there was absolutely no evidence from which this court could draw any reasonable inferences about why Mr. Sims shot. And the reason is because though we knew from the record that in the bar, Mr. Sims and the victim had engaged in some verbal altercations, the victim had made some racially derogatory comments towards Mr. Sims, what we didn't know is what happened in the parking lot when the victim got shot. There were two men enlisted in the Navy that observed the shooting, but all that they could say was that the victim appeared to go up to the vehicle, to shake his finger, maybe in an upset manner, but that was it. When Mr. Sims was arrested, and I can't remember whether he did or did not testify at trial, but what the opinion said was the only evidence that the court had was that Mr. Sims said, I drove off from the parking lot. I heard the shots, but I wasn't there. I was not the shooter. I wasn't there. So there was absolutely no evidence that the court had as to why Mr. Sims shot. That's not this case, because even though the defendant makes these mealy-mouthed denials that he wasn't the shooter, but he gave you the why as to why the shooting happened, we know what happened in that moment from Mr. Danshin's perspective. I am not asking this court to speculate and make up reasons. Mr. Danshin said that what the motivation behind this is it looked like he was going to cut her goddamn head off with the machete because he had already chased me with that same machete away from the room when I knocked on the door. That is Mr. Danshin relating what had previously occurred to him and why then in that moment when she was being dragged back by her hair and when Mr. Gonzalez Mena was holding that machete in his hand, it appeared to Mr. Danshin that Mr. Gonzalez Mena was going to cut her head off. Additionally, what would be the only reason that you would shoot someone? This is it, and then Mr. Danshin replies at 334 to 335. The only people that I would consider hurting are women and people who hurt women and children. I think most people would agree if somebody is going to kill a child, you do whatever you can to not let that happen. I understand Holly isn't a child, maybe she's a little bit older. And certainly, not only has there been clear-cut examples of what has already happened in this situation, but when you see a machete raised above someone's neck, what would you do? Then, moving on to Justice Gould's question, why at E355, why did you shoot Javier? I gave you the why. I saw someone in imminent threat of not just bodily harm, but imminent threat of lethal harm, and with complete knowledge that this person has hurt their victim previously on more than 2 occasions.
Can I ask you, the state in closing argument argued to the jury that the defendant in this case admitted to shooting?
Your Honor, I apologize. I would have to go back and review the state's closing argument as to whether or not they took the affirmative position that Mr. Danshin admitted to being the shooter. That I don't recall. Certainly it was the state's theory, and they secured the conviction that Mr. Danshin was in fact the shooter. But what I cited from the closing argument of the state in my brief was the fact that the state then, despite objecting to the defense of others' jury instruction, the state really seized on the defense of others and the fact that Mr. Danshin was not, quote unquote, the Good Samaritan that he claimed to be, that he was not the rescuer or the hero. That Good Samaritan language comes directly from the Lee case, which was a case that the state gave to the trial court. In this case, the trial court referenced it in its denial of the defense of others jury instruction.
And there was an instruction given that was only consistent with him being the shooter.
There was an instruction given, Your Honor, absolutely. It's a self-defense instruction. So clearly, and again, this goes back to what is the standard of sufficiency of the evidence. Was there evidence in the record that Mr. Danshin was the shooter? Yes, because that was submitted to the jury. And additionally, with respect to the self-defense instruction, was there evidence in the record that at the time of the shooting, Mr. Danshin actually believed that he was in immediate or imminent danger of death or bodily harm? The state, unlike in Jarvis, the state here on appeal has not doubled down and tried to argue to this court that the self-defense instruction should not have been given. And so while it was great that the self-defense instruction was given, frankly, that was not the issue in the case. The issue in the case, as framed by the prosecutor in the closing and rebuttal closing arguments, was Mr. Danshin the Good Samaritan that he claimed to be? Was he the rescuer of Christina Jones? Defense of others was the issue. In fact, Mr. Danshin, in his police statement, said, look, I'm studying to be Buddhist. I'm not going to kill somebody just because they're going to kill me. I'm going to forgive them. But if they come after a child or a woman, and then in this case, with the knowledge that I have of how he has treated her in the past and the threats that he made, threats, by the way, which were, I will kill you, I will cut you up, I have used a machete before. That's why in this, the Supreme Court of Maryland in Gunther versus State, and that was a self-defense case, but the Supreme Court of Maryland in Gunther said that there are instances where the court can draw reasonable inferences about the defendant's subjective state of mind at the time of the shooting, so long as there is some evidence from which you can base it on to then spring the inference. In Gunther, what the Supreme Court of Maryland said was that there was this prior knowledge that the victim in that case had been abusing the defendant's sister. It was the wife of the victim. Now, that victim had never made prior threats to the defendant himself, had never abused him. In fact, the day of the shooting, the victim and the defendant had no communication with one another. But in the critical moment when the victim jumped into the car in which the defendant was sitting, and it appears maybe the victim jumped on the defendant or got near the defendant. In that moment, the defendant shot the victim. And the Gunther court didn't require Mr. Gunther to explicitly say, well, I shot because I was in imminent fear of my life. And in fact, the knowledge that Mr. Gunther had was not that, he might be the target of an attack, but it was really the knowledge that the victim had a propensity for violence. He had physically and violently abused his wife the day before, and he was known to carry firearms. Now, Mr. Gunther didn't see a firearm that day, but he suspected that maybe Mr. Gunther had it when he jumped in on him in the vehicle. Our case is better, I would submit, and the reason is because Mr. Danshin knew that in the days prior, Ms. Christina Jones had been assaulted by Mr. Gonzalez-Mena, had threats made to her, I will kill you, I will cut you up, threatened with the machete previously, and then in the moment of the shooting, there is no dispute, because this was testified by Ms. Jones, and it was seen by the photographs when the police officers arrived on the scene, Mr. Gonzalez-Mena had that machete in his hand at the time of the shooting. There's also no dispute that he was physically hand in hand with Christina Jones at the time. Sure, there are inferences. The state in closing argument could say they were just hand in hand strolling together. She was actually pulling him back into the room. That's an inference. That's an argument. But there are also inferences that this court can make that it's not what happened. We know that Ms. Jones was a battered woman in all, sense of the words. She was somebody that was in an unhealthy relationship with a man who had made threats and had physically abused her in recent time to this shooting. She was in an argument with Mr. Gonzalez Mena in the hotel room about whether or not he had some stuff on his phone that she didn't like, and he hit her over the back of the head. And and again, this is defense of others. So there is a little bit of,
Did Mr. Danshin know that?
So, no, Your Honor. I can't say from the record that we know that Mr. Danshin knew that she had been hit in the head that night before coming over. But there is certainly evidence in the record from the text messages between Mr. Danshin and Mr. Scharnberg that they were worried about her, that the last time they had seen her, she had been crying to Mr. Danshin about what an awful person Mr. Gonzalez Mena was, and then all of a sudden she disappears and is back with Mr. Gonzalez Mena. We do know that Christina Jones made a phone call that night because Mr. Rugamas testified that Ms. Jones was on the phone at the motel room. We also know from Mr. Rugamas that Ms. Jones and Mr. Gonzalez Mena were arguing at the motel room. Ms. Jones testified, I believe, if I may just... Now, there was a dispute, I know, as to whether or not Mr. Scharnberg remembered having a phone call with Ms. Jones when she was at the hotel room. And I do concede, and I corrected in my reply brief, that Mr. Scharnberg said that he did not receive a call from Ms. Jones the night of June 22nd. However, when Ms. Jones testified, she was asked, when you spoke to Mr. Scharnberg, do you remember what you guys talked about? She answered, I just told him where I was. The phone was broken, in case he couldn't reach me. There were also, however, there was evidence here that Mr. Danshin asked Mr. Scharnberg if he had spoken with Jones, and Jones said yes, and that was in a text message at E286, and that Mr. Scharnberg told Mr. Danshin, sounds like dude was in the room with her, asked if she was okay, but it didn't seem like she could answer. So, no, to directly answer your question, I can't say that Mr. Danshin knew that there had been this fight in the hotel room, but Mr. Danshin knew from this text from Mr. Scharnberg that clearly it appeared that Ms. Jones really didn't want to talk because Mr. Gonzalez Mena was there. But it doesn't matter. It doesn't matter if he didn't know about that little fight because he knew about the other threats that were more egregious, the threats with a machete, and then at the moment of this shooting, he saw Mr. Gonzalez doing what he described as an overt act of dragging her back by the hair to the room, and he said a machete was held above her neck. This is similar, I would submit, to Wilson versus State with respect to the Supreme Court of Maryland finding that the trial court erred in not giving the imperfect self-defense instruction. In Wilson, what's interesting is that when the officers asked the defendant, well, what did you think when you saw the gun being pointed at you by the victim? The defendant said, kill or be killed. What are you going to do when somebody does that to you in that situation? But what then happened in Wilson was the defendant was able to grab the gun from the victim. Now, the Supreme Court of Maryland could have said, well, we don't have anything in the record to say why he still needed to shoot in that moment when he wrestled the gun away, but that wasn't required. In fact, the trial court, I found it interesting, if I may just... The trial court, in denying that imperfect self-defense instruction, said things that were similar to what the respondent has argued in its brief. The trial court at page 540 in Wilson said, there's no specific articulation of fear of death or serious imminent bodily harm. There's no specific articulation of observations that prompted his fear at that moment. There's no articulation of any behavior by the victim during that moment in time that could be pointed to as a source that would cause fear of imminent death or of death of serious bodily harm. But the Supreme Court in Maryland said, that's a task for the jury. The Supreme Court of Maryland said, importantly, was that the kill or be killed claim was, even if it was overwhelmed by evidence to the contrary, it was legally sufficient to require a jury determination of whether the state's evidence proved beyond a reasonable doubt that at the moment when he shot the victim, Petitioner did not have a subjective belief that he was in immediate danger of death or serious bodily harm. That's at page 543. So I would submit that this sum evidence standard in deciding whether or not the evidence is sufficient to propound the instruction does not require the trial court to find with absolute certainty what the defendant's state of mind was at the precise moment of the shooting. That really is still for the jury to decide. The question is, was there evidence generated from which the jury could, one juror, any juror, could possibly make the inference that when Danshin said that he gave the motivation for the shooting, he gave you the why, it was because at that moment of the shooting he actually believed that Ms. Jones was in imminent harm of serious bodily injury.
Does it matter the number of times a person shoots someone? In this case, I think the allegation is he shot him twice. Does it matter?
No, Your Honor. There are, most murder cases result in multiple gunshots being fired, and, for when you're involved, this is not the case, but just as an example, when you're involved in police shooting cases and excessive force, there are so many times we hear from the experts and we hear from officers that, once you pull the trigger, you're just in the moment. You're in the zone. When you feel that you have this need to act or to react, you're not thinking about how many times you're pulling the trigger. So here, this isn't a case of an extended magazine with 16 rounds being fired. It was 2 shots. And so I would say that is not part of the analysis. That could be argument. The state in closing argument could say he wasn't afraid. He actually wanted to punish this guy. We know he wanted to punish him because he fired 2 shots when he only could have fired 1. That's an argument. Or the argument goes the other way, like I just mentioned, that in this moment he was scared, he pulled, it was very quickly, it was successive, it was rapid, and there was no time in between the 2 shots to change his state of mind.
Ms. Coleman, you talked about the things that were in Mr. Danshin's mind, the imminent threats that he testified to, the text between he and Mr. Scharnberg. What about the physical injuries to Ms. Jones that Mr. Danshin observed? Do those factor into this analysis as to some evidence?
They do, Your Honor, and for that I would, again, discuss or point the court to the Gunther matter, but then also to Marr and Smullen, which are self-defense cases, but they talk about when you are assessing whether or not a defendant felt a certain way in the moment and whether or not what he felt was reasonable, you need to perceive or look at the circumstances from the defendant's standpoint. You need to at least consider what was he perceiving in that moment. This was not Mr. Danshin coming upon some strangers at the Red Roof Inn where he was seeing them hand in hand or even hair being dragged back. If any one of us were to be out in public and to see even a man perhaps, pulling a woman in a way that we did not think was appropriate, we may not immediately think, well, that woman is in danger of death. Now, if we saw a machete in the guy's hand, would we think so? Maybe. Maybe we would call 911. But what we have here is Mr. Danshin coming to the scene because he knows that this woman is with someone who is bad news, with somebody who has assaulted her recently. He knows of the abuse, to her chest, to her head, the things that she described to him both in person, on the phone, and through text message, all which is in the record, and all within 2 to 3 days. And I see I've gone into my rebuttal time, if I may just finish your question. But absolutely, that is something for us to consider was on his mind. And we know that because in his statement, he says 3 different times that he acted not just because of what he observed at the Red Roof Inn at that moment, but because it was coupled with his knowledge of the prior assaults on Ms. Jones. Thank you.
Okay, thank you, Ms. Coleman. We'll turn now to Mr. Donahoe.
Good morning, Mr. Chief Justice, Associate Justices. May it please the Court. Ms. Coleman. I wanted to respond at first to a question asked by Justice Killow while it's fresh in my mind about how the state in closing argued Mr. Danshin's statement, and they didn't argue it as a confession. They didn't present it as a confession. The state, in their closing argument, distinguished between evidence that described what had happened and evidence that spoke to why it had happened. And as to what had happened, they didn't talk about, the prosecution didn't talk about Mr. Danshin's statement. They talked about the evidence, the testimony from Ms. Jones. They talked about the testimony from Mr. Rugambus. They talked about the testimony from Wilmer Quintanilla, the person who drove the parties to the hotel, and they talked about the testimony of Micah Clemens. And I raise that both to respond to Your Honor's question, but also because I think this is a critical distinction. There's a distinction between what happened and why it happened. And that is sort of the central tension that we have in this case. It's hard to generate a defense of others. And that's not an accident. This court recognized in Sims and Martins that there are practical problems of proof. Because in these justification-type cases, defense of others, self-defense, almost uniquely in the law, the question is what a person actually, subjectively, and honestly believed at a specific moment in time, at the time that force was used, actually, subjectively, and honestly believed. This is a distinct question, distinct in kind, not just in degree, from the question of what one intended or what one happened. Those, of course, are fodder regularly for jury inferences, for the application of circumstantial evidence and these sorts of things.
I direct evidence here.
I don't think that we do. And I know that, Your Honor, and certainly recognize what Mr. Danshin said and I'm sorry, I had it a moment ago, at page 355. I gave you the why.
Well, there's a lot of other places in the transcript where he explained that he thought she was in imminent danger.
I don't think that it's personalized to her, and I don't think it's temporalized to that moment. I'll address the other ones, but just while I have it up, this exchange here, I gave you the why. One of the detective responds, well, I think I have. I think you have. I think you were trying to. Mr. Danshin then interrupts. No, I saw someone in imminent threat of not just bodily harm, but imminent threat of lethal bodily harm, and with complete knowledge that this person has hurt their victim previously on more than 2 occasions. We skip a few lines. The detective says, I appreciate that you're playing around with words, and Mr. Danshin says, I don't know what happened. And then on the next page, I only saw a little bit, and that's it. And that's consistent with the specific account, ultimately, that Mr. Danshin arrives on in his statement. We need to read, we need to consider his statement in toto, and I think that's one of the lessons that we can take from this Court's opinion in Jarvis, is that we can't take sentences, clauses, phrases out of the entire context of what was a 90-ish page transcript. There are a couple pages of title pages there, so it's not entire.
I read the whole transcript. It seems to me that Mr. Danshin was making what I think one could reasonably infer was a preposterous denial that he was the shooter, and at the same time trying to persuade the detectives that he did so justifiably. And it also seemed to me, and I'd like you to speak to this, that the detectives thought or strongly suspected that he did so for justifiable reasons. It was that they were trying to feed him. It was like leading questions. Please say that you were trying to help her. And he refused to go there, which I think one could reasonably say was preposterous. It was foolish of him, but nevertheless, he's entitled to be foolish, and the jury is entitled to see through his foolishness. So what am I missing?
Well, I agree at a broad level that the questions, the manner in which the interrogation was conducted was somewhat unusual, but I think it's also significant that the detectives tried to tee this up for Mr. Danshin, not once, not twice, several times, and he explicitly denied it.
And that's because that's what they believed. And if it appears that the detectives believed he was acting in defense of who he thought was Holly. That's what the detectives believe. So why wouldn't it be reasonable, based upon the same evidence, for the jury to reach that same conclusion?
I don't necessarily agree that it's clear that the detectives believed that. I think the detectives were trying to get him to say one way or another. Several points throughout the transcript, they say, we're trying to understand what the motivation was behind this. We're trying to understand what your perspective was when the shots were fired. I think maybe nowhere in the transcript is it clearer than in the pages that follow Mr. Danshin's statement, the gesture he makes, the pulling of the hair.
The jury had that video.
Right.
I think it's not only just the cold transcript, but watching the video, the jury can draw, inferences from his denials, but then statements that I gave you the why, and assess his credibility as to why he's giving those inconsistent statements. And it seems reasonable that a jury could conclude that he simply doesn't want to admit, but he's offering up the why, if you will.
And where the gun is located. He has no idea who the shooter is or what happened to the gun, but he's somehow able to tell the police where the gun is.
He does, ultimately. And I think that sort of shows that he's being coy with detectives, that his statement is entirely hypothetical, counterfactual, conditional. And the detectives at one point actually respond, I watched the video, respond with the same gesture. Immediately after Mr. Danshin says, the motivation behind this is I didn't shoot him. It looked like he was going to cut her head off with the machete because he had chased me with the same machete away from the room when I knocked on the door. Immediately thereafter, the detective says. And so what you're saying is when she's being grabbed and the guy has the machete, you shoot him because you're in fear that she's going to be harmed. No. He denies it. He explicitly denies that is what happened.
He denies, one way to understand it is in the context of the overall scheme is he denies that the shooting part, but it can be also read as not walking away completely from I saw her with the hair pulled back and the machete at her throat.
I think what he's denying there is that his motivation, that his actual subjective belief at the time was to protect Holly. That was the question that was asked of him.
Is it the state's position that denying that when a defendant denies he's the shooter, he has basically forfeited the legal ability to assert a self-defense or defense of others?
No. There are, in that situation, practical problems of proof. That's what this court said in Sims and Martin. And it is difficult, but probably not impossible, to generate some evidence when the defendant denies being the shooter. I'm sorry.
Along that line, then, and I'm looking at the statement that crosses over from page E382 to 383. This was only done to prevent imminent harm to a person and not like the potential harm, not the speculation of harm, but the actual imminent harm, because I already had clear evidence of the physical trauma. Why don't statements like that get there? Because it seems to me like he's not denying at any point here that the shooting was done to prevent imminent lethal harm. He denies that he was the shooter, but I read it pretty consistently throughout to say whoever did the shooting, this was to prevent lethal harm to her.
And my response at sort of a theoretical level would be that's not enough. The hypothetical, why someone
That's not enough. Haven't you gone back to what Justice Gould was saying, that you forfeit the ability to raise that defense unless you admit you were the shooter? No, because I think that those are distinct. Offering a hypothetical why someone might be shot is not the same thing as some evidence for... He specifically says it's not speculation, it is actual imminent harm. Well, and then we go after that. I have her own testimony, like, for example, Jenny and Amber heard of what was done to her. I think we need to read this in the whole context of his statement, where at first he denies even being there. Ultimately, the detectives sort of separate it into why he was there. And I read this, and I think that's how the court read it too, the trial court read it too, as an explanation for why he was there. And in his earlier statement at around page 350 of the extract, where he talks about the circumstances in which it might be appropriate to kill someone, he recognizes. He says, "Listen, I'm not the shooter, but I had some part to play in this. I pulled these people together," and then he leads into it. So I think the why he's talking about there isn't the why to the shooting, and this is sort of what the trial court talked about when it was
engaging in the discussion with counsel about whether the instruction was generated or not. It says, well, what is he actually seeing at the moment of the shooting? Not what leads him to go to the hotel, not...
But why isn't the Marr discussion appropriate here, where you have evidence in the record that text that Gonzalez-Mena pinned her down would cut her up like I did the last one. She says that he said he would kill her if he left. So why doesn't that inform what is going through his mind at the moment he shoots the gun when the victim is holding a machete? Why can't the jury consider that evidence as far as what is in his mind at the time?
Well, the text message, referring to the text message exchange between Mr. Scharnberg and Mr. Danshin
Yes.
on the night of, that doesn't reference specific threats as I read it. Mr. Danshin says, I'm concerned about Holly because I haven't seen her for a couple days. They'd had a date in effect about 3 days earlier. I haven't seen her for 3 days. And then he describes this earlier incident from June 20th of 2022, the assaults. And I mean, I can't really put it in any, I think, better language than the detectives did when they asked Mr. Danshin these questions. They said, listen, we know, we recognize these aren't good guys. But we need to know what your perspective was at the moment of the shooting. So I recognize that's not responsive to Your Honor's question. I think it can. I think it could in any way. And that's one of the lessons of Gunther. Of course, if you know that someone has committed acts of violence in the past, the state's not suggesting that that's categorically irrelevant. But it needs more. There needs to be some sort of temporal or circumstantial connection to what happened at the moment of the shooting. And I think Gunther provides a good example of that. Now, I'll point out the legal background in Gunther is a little different because, as I understand it, the specific question was about whether the defendant was precluded from asking for this defense because he armed himself in anticipation of going to it. But the victim was in the car, and the victim was actually assaulting Mr. Gunther at the moment of the shooting. And so we have something more in that case. This isn't just a fear based on what had happened even in the days before. But we had something more, something tangible in that case. And I just would suggest to the court that reading Mr. Danshin's statement in its entirety...
Don't you think there's evidence that Mr. Gonzalez-Mena was also assaulting Ms. Jones right before the moment of the shot? I mean, we don't know, I guess, definitively what, as Ms. Coleman pointed out, whether they're just holding hands, strolling, or whether he's dragging her. But, there could be an inference that he was assaulting her, that he had a machete at her throat and grabbed her and had her hair, and that was an assault similar to arguably what you were just talking about in the Gunther case.
I don't think so. When we're talking about the moment of the shooting, Ms. Jones's testimony isn't the subject of inferences. I'm talking specifically here about the moment of the shooting. She said she was holding her boyfriend's hand and they were walking back to the hotel.
I'm referring more just to what I understood to be Mr. Danshin's statement about this.
Yes, and we get to Mr. Danshin's sort of specific articulation, his narrative of the events, as clearly as we can find it between pages 339 and 350, I guess, about of the transcript, where he grounds these descriptions of seeing Ms. Jones's hair pulled. And what he says is that he and Mr. Clemens went to the hotel room. They knocked on the door. The two occupants of the hotel room came out and they brandished machetes. They chased them down the stairs. They both fled. No disagreement at that point. What Mr. Danshin says is that he then sees Holly. He then sees Ms. Jones at the landing, and he sees Mr. Gonzalez-Mena pulling her hair at that point in time, and he reaches up and grabs her. And they flee together, and that is when they hear gunshots. That's within his entire statement, the clearest explanation of this hair-pulling incident. And again, I can't really put it any better than the trial court did as it was working through this issue with counsel. He says, well, what does he actually see at the moment of the shooting? And we don't have that.
So in one explanation, Holly was with him when the gunshots were fired. Is that what you're saying?
That was his.
Okay. And in other explanations, he said she was in imminent harm, and from what he saw. So I assume he wasn't confessing that he was putting Holly in a position of imminent harm. I'm sorry. Isn't that an inherent contradiction? I mean, it seems like there's a lot of contradictions in his statement. And
I would agree.
Isn't it the jury's job to sort it out, to see what is the truth?
The court does have a gatekeeping function, though. The court has to determine whether the proponent of an instruction has provided some evidence that would permit that would rationally permit the foreign.
Not whether they provided it, whether they can point to it. They don't have to provide the evidence.
That's right. I'm sorry.
It can be provided by anybody.
That's correct. Yeah, and I'm not suggesting that Mr. Danshin couldn't because it was the state that introduced his statement. That's absolutely correct.
The trial court here said, as I recall, that because Holly could not have asserted self-defense, then he could not assert defense of others. Do you agree with that legal principle? It seemed like that was a legal principle that the court was applying.
I don't agree that was a correct statement of the law. And as we point out in the briefing, it has been some time since this court has had the occasion squarely to address the defense of others. Lee, the appellate court of Maryland opinion, I think is probably the most recent and clearest. And I don't want to misquote the appellate court, but they say something like that proposition that you step into the shoes of the protectee has been, that I don't think they say rejected, but we've cast doubt on it. And I'm not suggesting that that's what it was, but that specific passage was after the court had already decided not to give the defense of others instruction. And
what generated the self-defense instruction here?
So I don't want to speak for the trial court. The trial court recognized clearly. That's a weird way to start my response. I apologize. The trial court recognized that its job wasn't to make credibility determinations. It said, listen, we just need something in the record that generates it. And we have testimony from Mr. Rugamis and Mr. Clemens that at this initial interaction at the doorway, they were chased away with machetes. And effectively, that's what generated the self-defense instruction, as I read the trial court statement. Now, the prosecutor responded, well, we don't have evidence that they didn't precipitate this, that they couldn't have safely retreated, and these sorts of things. My recollection is that the court didn't address those. It was really just based on the fact that Mr. Rugamis and Gonzalez-Mena chased Clemens and Danshin away from the doorway when they first arrived with machetes. I'd point out as well that in Mr. Danshin's statement, he said, I may have had an intent to scare them. I may have had an intent to protect myself. He actually uses the words, I may have had an intent to act in self-defense or something like that. And so the court didn't address that. But he actually uses the word self-defense in his statement as well.
Well, actually at trial, when the trial court was considering whether or not to give the self-defense instruction, the assistant state's attorney argued that in his statement, Mr. Danshin was talking about what he believed Christina being under threat rather than himself.
I'm sorry, can I?
Page 234 in the record extract where Mr. Carrera is opposing the instruction on self-defense, and Mr. Carrera characterizes Mr. Danshin's statements in his interview as being his belief that Christina is under threat rather than himself. Can you comment on that?
I see what Your Honor is saying. Unfortunately, the record extract skips a couple pages there. It goes from 11 to 14 of the original trial transcript. I can't explain that, but clearly the state's position in this exchange was not that defense of others was generated because...
I know, but what I'm pointing out, that's not consistent with the manner in which you just answered Chief Justice Fader's question that he referred to self-defense in his statement. That's not what was told.
And as I I meant to indicate if I didn't. The trial court didn't catch that. No one caught the fact that in Mr. Danshin's statement he actually uses the words self-defense.
Right, I did not
I
see
didn't mean
that
to.
at all in the transcript. It appeared that the state opposed the giving of the self-defense instruction
That's right.
on the grounds that when he spoke with the detectives, he was referring or giving reasons about why Christina was in fear rather than himself.
I'm sorry, I'm not.
It's on page 234. The state is opposing the self-defense instruction and advising the trial court that Mr. Danshin's statements to the detectives went to Christina, his belief that Christina was under threat, not himself.
That they do say that at page 234, but when they moved to the defense of others portion of this, the state clearly said, and they talked about his statement too, Mr. Danshin's statement. I don't know what.
When they moved to the defense of others, the state argued the Lee case primarily.
Yep.
And argued that there was no evidence that Christina was under direct attack. It appeared that the trial court was convinced that in order to give the instruction on defense of others, there had to be some evidence that Christina was under an immediate direct attack.
I accept that. I agree. That is what the trial court quoted from Lee, and it said immediate or imminent, and so it recognized that those are sort of discrete concepts. I know.
Do you believe if the trial court's ruling was cabined to the belief that the person there had to be evidence that the person was under direct attack, that is a legally correct ruling?
That the protectee, in this case Ms. Jones, had to be under direct. I think that is a correct ruling, and I think that's sort of an application of the requirement that no more force be used than is necessary.
So his subjective belief, whether it's reasonable or not, that there could have been imminent or immediate danger of serious bodily injury or death, translates into the need to show evidence of a direct attack.
I think it's the requirement that no more force be used than is necessary that gets at that direct attack language that we find in Lee. I mean, I think they're related, all four of these elements, but as I was thinking about this, I think that direct attack language, in Lee, encompasses both immediate and imminent. I recognize, I'm not disputing that.
It seems that there was some very specific language pulled out of Lee and given to the trial court that the trial court relied on that may be more narrow than the actual test for giving an instruction on defense of others.
I think, the court quoted Lee. I think the court also quoted, in any event, the court had, the request was for the model pattern jury instruction. That's the sheet of music that everyone was playing from. So the court clearly knew what the four elements to generate a defense of others instruction were, an imperfect defense of others instruction were.
Can you tell me the page in the transcript that you're relying on where the court reviewed those elements and ruled?
I apologize. I can't immediately find it, Your Honor. And I may have accidentally been referring to the discussion the court was talking about the elements for from the standard instruction for self-defense.
Yeah, that's right. It appears that the court believed that the interview with Mr. Danshin showed that Mr. Danshin thought Christina was under threat, but refused to give the defense of others instruction because the court believed there needed to be a direct attack shown.
I think that that's probably a fair reading of the court's reason for denying to give the defense of others instruction. I think it's also probably correct, and didn't use the words when deciding not to do that, imminent or immediate, although it did use those words through the course of its...
I didn't see anywhere where the court really evaluated what's required, the elements that you're talking about, for the defense of others' instruction and made a ruling based on those elements.
Well, the court on 2E, 244, and 245 is going through Mr. Danshin's statement again and saying, and I'm here on page 245, E245, but brackets, Mr. Danshin doesn't describe what it is he's seen. So the court thinks he has to make that next step of saying, I saw him swinging the machete at her, or he was yelling that he was going to, whatever the scenario is. It's not in here, at least. And so I read that, rightly or wrongly, I read that as the court saying that this attack wasn't, reviewing Mr. Danshin's statement and saying that he didn't describe an imminent or immediate attack. It didn't describe a direct attack. And I apologize if I'm not understanding your honest question.
Can I ask you whether you agree with me that Mrs. Jones' subjective belief regarding whether or not she was in danger is not relevant to the question of whether Mr. Danshin had a subjective belief that she was in danger?
I absolutely agree with that.
You agree that the judge was wrong, then the trial judge was wrong when she says on page 248 that, and if he can't generate that self-defense instruction, he can't generate that defense of others instruction in this case.
That is incorrect. I would agree with that. Because the defense of others is personal. It's personal to that defendant. I would like briefly to talk about, Ms. Jones's testimony. She describes the immediate aftermath of the shooting, and she puts her hands in the air, and she makes some sort of reference. Well, she thought maybe it was a police officer because Mr. Gonzalez-Mena had the machete in her hand. But she was afraid that she was going to be shot, too. She's describing an indiscriminate shooting, not a justified.
The jury believes her.
I'm sorry?
But the jury's entitled to believe or disbelieve any
Absolutely
or
right.
all of it.
Absolutely right. I raise that to say that her statement can't generate, just taken at face value, can't provide some evidence of what Mr. Danshin subjectively believed. That's the limited point that I was trying to make with that. And so if the court has no further questions, the state would respectfully request that this court affirm Mr. Danshin's convictions. Thank you.
I see no further questions, so thank you, Mr. Donahoe. And we have, Ms. Coleman has 6 minutes and 44 seconds for rebuttal.
Justice Watts, you asked questions about the trial court's actual holding regarding the defense of others instruction. And in respondent's brief at page 29, where it cites to some of the statements that the trial court made about why it was denying the defense of others instruction, I would point out that respondent's brief at 29 cites to E244, 245, kind of the pages leading up to the holding, but it does not actually cite there E247 to 248, which is the actual holding. On 247 to 248, the trial court said, quote, I want to make sure that I make a record as to why the court's declining to give it. If the court were to view from Ms. Jones's perspective, would have the right to defend herself in a certain scenario like anyone else does, the court would still find in this scenario if Ms. Jones had acted in some manner where she shot Javier and the evidence in the testimony was the same, which was there was no wielding of the machete at her, There were no threats being made. There's been no evidence of wielding machetes at her. There's been no testimony of wielding machetes generally at the two people who came to the door, but no testimony related to her. She wouldn't have generated a self-defense instruction based on the evidence that's before the court. And if she can't generate that self-defense instruction, he can't generate that defense of others instruction in this case. That was the wrong standard. The court, at least the appellate court of Maryland, has held in Alexander versus State, and that case was actually affirmed by the Supreme Court of Maryland per curiam, so there was no opinion attached to it. But the appellate court held that the trial court erred when it instructed the jury that the defendant intervened to aid an apparent victim of assault, and that the defendant had a right to go to the defense of the apparent victim to the same extent that such victim had a right to defend himself, in that the defendant had to be judged on his own conduct based on his own observation of the circumstances as they reasonably appeared to him. Alexander abrogated Guerrero and Tipton, which were the prior cases from decades earlier that said that there had to be a coterminous right to self-defense in order for the defendant to be able to use the defense of others instruction. But even the Lee case, which was more recent in 2010, said that the more enlightened view comes from Gray and Alexander, which you don't step into the shoes of the victim or of the person being protected. Rather, you assess defense of others from the perspective of the defendant as he comes onto the scene. The Alexander opinion says that a defendant is protected by the usual mistake of fact doctrine and may act upon the situation as it reasonably seems to be. The Alexander opinion, I think, is also instructive for this court because there it recounted, quote, divergent facts between the two sides, but said the issue here is not which version to believe, for that, of course, is the role of the fact finder. In Alexander, the facts were that this happened inside of a prison, and Alexander was a prisoner who was observing a fellow prisoner be assaulted by a prison guard. Now, what Alexander did not see was that that prisoner had actually assaulted the prison guard first. But when Alexander came upon the scene, he saw the prison guard assaulting his friend, so he stepped in to assault the prison guard. The appellate court said it may have very well been that his motives were not pure in stepping in, that this might have been an opportunity for him to just go after this prison guard. But that's not the test. It's for the jury to decide what Alexander felt in that moment and whether to believe his statement and the inferences therefrom or to believe the state's evidence. Justice Kelo, with respect to your question about whether Ms. Jones's subjective belief is relevant, I would say it is relevant. It certainly cannot supplant and stand in the shoes of the subjective belief of Mr. Danshin, but once there has been some evidence, some shred, which this record contains as to why Mr. Danshin acted in those circumstances, it is then a fair inference to consider objectively other evidence in the record. Jarvis, Sims, and Martin all speak to that, to the fact that so long as there is some evidence from which an inference can spring, you can then consider the evidence in the totality, including the fact that Christina Jones testified that when they were coming around the corner, they were coming so fast, there was the machete in Mr. Gonzalez-Mena's hand, that when she heard the shooting, she actually thought it was a police officer who must have been scared at how fast they were coming at them with the machete. With respect to the passage E332 to 333, where respondent argued that Mr. Danshin said, well, no, I didn't shoot because I was afraid for Ms. Jones's well-being. Justice Braun, I think you rightly pointed out that Mr. Danshin was not denying that the shooting occurred because Ms. Jones was in imminent danger of death or serious bodily harm. He was merely denying at that point being the shooter. He was backpedaling. He was trying to walk around admitting being the shooter, but he never denied that the shooting occurred because she was in imminent danger of death or serious bodily harm. And Justice Fader, Chief Justice Fader, you spoke to that as well when pointing to E 382 to 383. He said specifically this was only done to prevent imminent lethal harm. So, Your Honors, I would ask you to take a reasonable approach to the record in this case, to not ask yourself whether you're convinced beyond a reasonable doubt of defense of others, but whether any rational juror possibly could have found that the defense of others instruction was applicable. I would ask you to reverse both the Appellate Court of Maryland and the trial court and to remand for a new trial. Thank you.
Okay, thank you both for your arguments. Case number 39 is submitted, and the court will stand adjourned until 9 o'clock in the morning on May 5th.
All rise.